Limtiaco versus Camacho is an obscure United States Supreme Court case that was decided in 2007. Most people have never heard of it. It doesn't make it into any legal books. Maybe you heard about it if you're a Guam attorney, and maybe you might cite it if you're working in the Guam Supreme Court or arguing a case before them. But other than that, very few people have heard about this case. I just happened to read about it while I was reading a book, and when I read the case notes and then I read the opinion, I realized that this case is one of the most strong indictments of American empire that exists in the modern era. And that's a big promise that I'm making, but stick around to the end of this video and you'll agree. I'm not a lawyer. I'm not Guamanian. I don't have any particular expertise on Guam. I've never even been there. But I can recognize the severity of this case. I searched YouTube. I was hoping that there would be other videos on this topic. There are none. I was only able to find a few articles written kind of concurrently with the case itself. It seems to have mostly fallen into the memory hole and kind of been forgotten. So first we need some backstory. Guam is a colony of the United States. Because the United States and most of its citizens are in deep denial about this, in the law books they call it an unincorporated territory. But this is just a nicety. It's just like calling your mistress an unincorporated wife. It's a ridiculous statement that, of course, it makes sense to American legislators, but it doesn't make any sense to normal people. So Guam is a colony, just similar to Puerto Rico, but unlike Puerto Rico, Guam is not part of the so-called Guam Commonwealth. The U.S. Virgin Islands have the same legal status as Guam. Some would say that a 1982 referendum is proof that Guam is quote-unquote rightfully American, but to me it's only proof of the effectiveness of late 20th century American propaganda. Had other empires held votes during their reigns, the results would be much the same. Think of the Soviet Union. If they had held a vote in Kiev about, are you happy being a Soviet, I'm sure most people in that city at that time, especially when the Soviet Union was ascendant, would have voted yes. So that's all the backstory we really need. The year is 2003, and Guam is finally being allowed to elect its governor. And that governor is Felix Camacho. He has a big problem, though. As a far-flung American territory that most Americans don't even know exists, and as a governor whose job has only existed since 1968, even though the U.S. had occupied Guam for 70 years prior to that, meaning for 70 years there was no elected government of Guam, pretty much, or there was no elected, head of Guam, as there are of all other territories and states. He's not at the top of the agenda in Washington, D.C. In fact, Guam does not even have a single vote in Washington, D.C. They have what's called, and get ready for this, a non-voting delegate. I don't really know a more imperialist term than that. A non-voting delegate. Again, it's just more American legalese to obscure the truth of the situation, which is that Guam is a subdued colony, and they are allowed to listen to their masters make their rules, but they're not allowed any input. Maybe they can, enter the floor of the house, but that's only because the American state is granting them that right. And they should view that as a great privilege that we're letting them listen to our public hearings and maybe speak to, some of the representatives on the floor. Wow, what a privilege. But other than that, they have no legal power over anything. They don't get to vote, and they are part of a miserable bunch of people in the House and the Senate, maybe even only the House, who, the Northern Mariana Islands, American Samoa, Puerto Rico, who have no say in anything. So, that's really the situation. He needs money very badly. Now, he decides to issue some bonds, and those bonds need to be signed by the Attorney General. The Attorney General at the time is Douglas Moylan. Thus, sometimes this case is also known as Moylan versus Camacho. He refuses to sign. Why? The Guam Organic Act provides, quote, that no public indebtedness of Guam shall be authorized or allowed in excess of 10% of the aggregate tax valuation of the property in Guam. So these were the terms that were dictated to Guam by, the American Congress in 1950. And basically, the aggregate tax valuation of all property in Guam, 10% of that is what the government of Guam is allowed to have as their debt. What's not good for the goose is good for the gander. The American state, no way that they could have this kind of indebtedness level, right? This is a colony, and they don't have to follow the rules of the sovereign of the United States. Yeah, it is that ridiculous. One thing I like about the text of this is per centum. Not percent, per centum. It's really pompous. They really feel that they're important, and they're speaking Latin here. Instead of using the generally accepted term percent, it's per centum. Wow, you really taught my ignorant self something. Anyway, like I said, it's 2003. George W. Bush is president. Republicans control Congress. The idea that the United States would ever run a permanent deficit is unthinkable at the time. It's happening right now. But then, it was unthinkable. In fact, in the Clinton years, they had, for a time, even a budget surplus. So Moylan, as a fiscal conservative, sees this act and this rule as a way to control spending. So he refuses to sign the bonds, and he's sued by the governor for refusing. It's Camacho versus Moylan in the Guam Supreme Court. So here's where things get interesting. He's sued, like I said, in the Supreme Court of Guam, and he loses in the Supreme Court of Guam. And it seems like that's where it should end, shouldn't it? But that's not where it will end, because, of course, we are allowing, and by we, I mean the sovereign power of the United States, is allowing these, Guamanians some level of control. But, of course, we're not going to let their court be the final court. Are you joking? Where's our power going to come from? So they can appeal to a higher federal court, the Ninth Circuit Court of Appeals. And the problem, though, is that this Ninth Circuit Court of Appeals is very known for being liberal. That's not a problem if you are on Guam's side, but it's a problem if you're on Moylan's side and the Republican side. So the problem with being a colony is that you don't control your own destiny. And when Camacho brought this case against Moylan, he probably knew that it could be appealed to the Ninth Circuit Court of Appeals, but he also knew that the Ninth Circuit is a very liberal circuit, and he's most likely to win there. So what the Republicans in Congress did is they did something very sneaky. This whole debate is about the Guam Organic Act. And the Guam Organic Act is where this whole 10% is coming from, right? So they could have just modified the Guam Organic Act at the time, and the whole case would have been irrelevant because Congress, had explained what they meant. And this happens all the time. Congress will modify an act, and then the whole case becomes moot. But that's not what they did. They did something a lot sneakier and a lot more kind of political theater, a political dance. So they modified the Guam Organic Act, but they didn't explain anything about the tax part. That would be seen as too obviously meddling. That's so 1920s. We don't want people to know that we're their masters. We just want them to be good little servants. So what they decide to do instead is deprive the Ninth Circuit of its appellate jurisdiction. And they give that jurisdiction to the Supreme Court. So they take it away, in effect, from a liberal court, the Ninth Circuit Court of Appeals, and they give it to a, at the time, conservative court, and still, now, a conservative court, the Supreme Court of the United States. And then here we are, the stage is set, right? The Ninth Circuit can no longer take the case, so they're forced to drop the appeal, right? They can no longer take it. It's illegal. They don't have the jurisdiction anymore. They were deprived of it. So Moylan then decides to, take his losing case that he's lost, and even he even needed Congress to put it in a more favorable court to even give him a chance of winning. So Moylan takes his pathetic little case and he, lodges it in the Supreme Court of the United States. Clarence Thomas writes the opinion of the court. It's decided 5-4 conservatives against liberals. It's interesting because at the time, this whole 5-4 conservative versus liberal, it was just becoming common. The court had not been so politicized in past generations. But this is a very partisan case. And what do they decide? Well, of course, exactly what Congress knew they would decide, to overturn the decision of the Supreme Court of Guam. I'm going to read 2 choice paragraphs from the opinion just so you can see the level of imperialism that's at play here. So, here they are. Finally, the governor mistakenly argues that we owe deference to the Guam Supreme Court's interpretation of its organic act. It may be true that we accord deference to territorial courts over matters of purely local concern. You can see, for example, Purnell versus Southall Realty. This case does not fit that mold, however. The debt limitation provision protects both Guamanians and the United States from the potential consequences of territorial insolvency. Thus, this case is not of purely local concern. Of course, decisions of the Supreme Court of Guam, as with other territorial courts, are instructive and are entitled to respect when they indicate how statutory issues, including the Organic Act, apply to matters of local concern. On the other hand, the Organic Act is a federal statute, which we are bound to construe according to its terms. For the foregoing reasons, we reverse the judgment of the Guam Supreme Court and remand the case for proceedings not inconsistent with that opinion. It is so ordered. So, what does this say? The governor of Guam mistakenly argues that we owe deference to the Guam Supreme Court's interpretation of its Organic Act. Okay, that's some legalese. Let me tell you it in plain English. This governor, this indigenous person, thinks that he can come to the United States Supreme Court and tell us that we owe him deference? We don't owe him any deference at all. Are you joking? We are, this isn't of purely local concern. Guam, a tiny island, might run up such a big debt that it'll make the whole United States fall apart. There's no other way to put it than that this case and this opinion is racist. This opinion says that the people of Guam, which is an island of such a small stature, are ignorant. They don't know how to read our laws. They can't figure out how to assess the value of property. They need us to come in for their own good and protect them from going insolvent. I find it interesting that they chose Thomas to write this, because he was joined by the other conservatives on the court, Roberts, Scalia, Kennedy, and Breyer. It's interesting that they had Thomas write the opinion and deliver it. Most likely, because this is such a blatantly racist opinion, the 4 white guys that concurred said, you know what, why don't we have the one black guy deliver it so that this racist opinion, there's a little bit of cover for us. But, when there's 4 white guys and 1 black guy, and all 4 of those white guys, their votes are needed, it doesn't take a genius to see that this is a racist decision. And it's interesting, none of these people have any connection to Guam. They don't care what happens in Guam, beyond the care that anybody has for strangers that they don't know. So they get to decide, though, this important issue. And it's not like if they had gone the other way that Guam would have ran up so much debt that it would have tanked the entire United States economy. The differences between the numbers were like a tripling. So they could have taken on 3 times as much debt as before. But remember, that would only be 10% of all property in Guam. Either way, it would just be calculated based on the value of the property and not the tax assessment on the property. We, therefore, will decide for you how much debt you can take on. It's interesting that this was decided in 2007, how far the conservatives in government at all levels have just totally decided to ignore any pretense of caring about saving money. They will happily spend money when they're in power. They just don't like it when they're not in power, because it serves as a tool to bludgeon the opposition. If you don't think America is an imperialist power, you're brainwashed. You listen to too much American pageant history textbook. And the facts of this case are really enough to show anybody. The United States government will do whatever it has to exert power over its colonies. And if that means that Congress, Congress can barely pass anything, but it somehow passed this act. If that means that Congress has to pass acts like this, and it has to be strong-armed, then so be it. This case is extremely important, and if you've held out to the end, I linked a few resources about it in the description. Thank you very much for listening.